Do I have a winning probate litigation claim? That's your question, isn't it? I'm Jerry Carter with the Crest Business Law Group. A lot of people come and consult with us and they want to know if they have a winning probate litigation claim coming out of some dispute that they have with a family member after someone has passed away. And I want to talk to you about what a winning probate litigation claim looks like. When it comes to probate litigation, people usually come into one of three groups. The first group of people with a probate litigation issue are people who are actually named in a will or a trust as being in charge. They would be called the executor or executrix in a will. They would be called a trustee in the trust. And if there is no will, that would be the person who's the next of kin, who under the law is entitled to take control of the estate and administer the probate estate. People in that group usually are going to win any contest involving a probate litigation. And the reason is because they have access to the property of the probate. They can afford to hire an attorney to be advised, and as long as they're reasonable, their recommendations to the court are generally going to be approved. So you want to be in that first group. You want to be a named executor, executrix, trustee, or next of kin, and really be clothed with that authority, be able to hire an attorney to get advice so you do it right and you will win. And then in probate litigation, there's a second tier of people, a second group, and those are people who, even though they're not in charge, they're named in the instruments. So if there's a will, they're named as one of the heirs. If there's a trust, they're named as one of the beneficiaries. Or if there's no will or trust, then they're one of the people recognized by Nevada law as being a legitimate heir. Those are usually children, spouses, and some other close family members. If you're one of those people, you're either named in the trust, named in the will, or you're a child, spouse, or a close family member, you're going to have some rights as a beneficiary and as an heir. And to the extent that there's probate litigation over that, you're generally going to come out okay because you have a clear established right. So now we get to the third group when we talk about probate litigation. The first group, they're the executors, the trustees. The second is the heirs, the beneficiaries with a clear legal right. The third group is everybody else. And if you're in this group, hate to break it to you, but you have an uphill battle because you're not named as the person in charge of the estate. You're not named as a beneficiary. You might have been intentionally or unintentionally disinherited. Any number of things could happen. So what it means is if you're in group 3, if you're not named as the executor or trustee, you're not in group 2 with the beneficiaries and the named beneficiaries, the named heirs, you're there in that group 3, you have an uphill legal battle. It's going to potentially be expensive, it'll be contested, and the situation might be unfair, but it doesn't take away from the fact that it's a difficult situation to be in. So here's what I would say. If you're thinking about which group you fall into and what your chances are, the best thing you can do is talk to an attorney. If you're in group 1, you're the executor, you're the trustee, absolutely talk to an attorney because you have the right to get an attorney that the estate is going to pay for, and that person will help you, that attorney will help you stay on the straight and narrow, do things right so that you don't have any problems. So if you're in group 2, you're named as an heir, you're named as a beneficiary, or you're in that statutory line of succession, then you definitely want to talk to an attorney to find out if what's the value of your beneficiary heir right is and what the nature of the dispute around it is, and find out if it's cost effective and it makes sense for you to hire an attorney to protect that right. If you're in group 3, you're part of everybody else, I would recommend that you do talk to an attorney. Just be prepared that that conversation is going to be long because the attorney's got to really dig deep and understand what the nature of your claim is, what facts, F-A-C-T-S, you can bring to bear to show that you've been treated unfairly, and realistically assess your chances. This is a group where you have to be totally realistic and candid about what makes sense, what's cost effective. So now that you know what a good probate litigation claim looks like and who are the people who are likely to have the best probate litigation claims, you probably have a lot of questions. We're happy to answer those questions. Give us a call at the Sierra Crest Business Law Group.